A motion to suppress, filed under Penal Code 1538.5, asks a judge to exclude evidence that was gathered in violation of your constitutional rights. The Fourth Amendment protects you from unreasonable searches and seizures, and when police cross that line, what they collected can be removed from the case. The underlying principle is called the exclusionary rule. Evidence obtained through an unlawful search or seizure is generally not admissible in court. The purpose is straightforward. If illegal police work produces no usable evidence, there is less incentive to cut corners. In a DUI, the most common target for a suppression motion is the traffic stop itself. An officer must have a valid legal reason to pull you over. If that reason did not exist, everything that followed, the field sobriety tests, the breath reading, the officer's observations, can potentially be excluded. This flows from a doctrine sometimes called fruit of the poisonous tree. If the initial police action was unlawful, the evidence that grew out of it is tainted too. A single bad stop can unravel the entire chain of evidence. The stop is the most common target, but not the only one. A motion to suppress can also challenge a detention that lasted too long or expanded without justification, an arrest made without probable cause, or a blood draw taken without a warrant or valid consent where one was required. Sobriety checkpoints have their own rules. A checkpoint is lawful only when it follows strict legal requirements, and a checkpoint that does not meet those requirements can be challenged the same way. A suppression motion is decided at a pretrial hearing, before any jury is seated. The prosecution generally must justify the officer's conduct, and your attorney can cross-examine that officer under oath, often for the very first time. This is a real chance to test the police report against the actual testimony and any video recording of the stop. Reports are written to present the officer's conduct in the best light. A suppression hearing is the mechanism that tests that narrative against the actual law and the actual record. When a suppression motion succeeds, the excluded evidence is off the table. In a DUI, that often means the breath result and the officer's direct observations are gone, and without those the prosecution frequently cannot prove the charge, so the case may be dismissed. Even a partial result matters. Exposing weaknesses in the officer's account, getting some evidence excluded, or simply forcing the prosecution to defend its conduct under oath can shift how the case resolves. Results vary, and no outcome is promised, but the suppression hearing is often where a DUI case is quietly decided before trial is ever a question. A motion to suppress is one of the most powerful tools in a California DUI defense, and whether your case has grounds for one is exactly what a careful review reveals. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.